In this lecture, we're going to be looking at jurors and juries, and in particular, we're going to be talking about the effect of deliberation on jury decision making. Now, what I'm going to do in this lecture is share with you some studies that were done in my lab that look at deliberation in one way, and there are lots of studies, but I just want to mention that deliberation is often the one thing that psycholegal researchers just don't do. They often look at jurors rather than deliberating juries. And that's because doing studies where you have groups of 6 to 12 people, it's much harder to do than to do just simply a study where you have individuals. Anyway, let's take a look at the effects of deliberation. Well, in the psycholegal literature, there's this theory of jury deliberation called the story model. And what it basically suggests is that the way that jurors think about evidence is they think about a story. And the story is often presented by one of the attorneys. So in the opening statements, the attorney will say, "This is the story. This is the story of the defendant who was jealous of his ex-wife, became enraged, went out and killed her. That's the story." The other story is the other side. The defense says, no, the defendant did not kill his ex-wife. In fact, the police officers were racist. The man was African American, wife was white. They manufactured evidence. There was all kinds of mistakes, and they got the wrong man. So you have two different stories. Some of you may recognize these two stories. They were essentially the O.J. Simpson trial. So jurors then try to fit some of the evidence into the stories. And according to one researcher by the name of Deanna Kuhn, there are different types of jurors in terms of their willingness to consider multiple stories. So let's take a look at that. On one end, Deanna Kuhn talks about somebody who fits more of the satisficing model. Okay, this is someone who constructs one story. Okay, maybe they glom onto the prosecution story, and that's the story that they stick with throughout the trial. A satisficer tends to ignore evidence that doesn't fit their story. So they may hear things from the other side, but they don't. It doesn't fit their story, so they tend to ignore it. Then, when all the evidence is done, they compare the verdicts with the story that they have glommed onto, and they choose the verdict that fits. Okay? And keep in mind, for satisficers, they may have actually adopted a story during the opening statements. And I don't know if you all realize this, but opening statements are not evidence. Okay? It's just the place where the attorneys try to craft the story that they're going to tell throughout the trial. So a satisficer then is thinking about the evidence at a very low level, and actually not considering multiple sides. Now, on the other end of the continuum, and by the way, there's no such thing as complete satisficers or complete theory evidence coordinators, but on the other end is what we call the theory evidence coordinators. Okay, these are jurors that construct multiple stories. So they hear the story that the prosecutor gives, they hear the story that the defense gives. Now they have two stories. And they keep those stories in their mind as they listen to the evidence. Now, each story will probably correspond with a possible verdict. Obviously, the one story that this man was jealous of his ex-wife and was enraged by her dating other men, that verdict might be first-degree murder. Racist cops who plant evidence, of course, that would be a not guilty verdict. So each story then holds a possible verdict. A theory evidence coordinator then listens to the evidence, and for one story and evidence that goes against that story. So while they're listening to the evidence, some evidence will stack up on the side one story and some will stack up on the other side. And when they finally get all done, what they do is they choose the story that best fits the evidence and then the corresponding verdict. So you can see a theory evidence coordinator is really doing what we want jurors to do. Okay? So what do we know about theory evidence coordinators versus satisficers? Well, Deanna Kuhn has done some work looking at people who, Again, this is a scale. It varies from, towards the satisficing end or towards the theory evidence coordination end. And what she found was that reasoning impacts outcome. So what she found was that satisficers were much more likely to give extreme verdicts. And they were also more certain of the verdicts that they gave when they made their decision. Theory evidence coordinators, on the other hand, were more likely to provide moderate verdicts. And they were also less certain about their verdicts. And this makes sense, right? Because theory evidence coordinators understand that they did the best they could, and the story that they picked was the best, but it didn't necessarily fit all the evidence. And so their verdicts also tend to be a little bit more moderate. So what does this have to do with deliberation? Well, there was a study that one of my graduate students and I did some time ago, and we were looking at whether or not deliberation improved reasoning in a particular case. So what we're asking is not so much are there individual differences in terms of the satisficers or theory evidence coordinators. We were wondering whether deliberation itself raises your reasoning level about a particular case. So I'm going to show you the results of the study, but let me just tell you a little bit about the study. It was a great trial. This is an actual trial that happened. This is a case that happened in Denver some years ago. And it was kind of an interesting case because a man was on trial for stabbing another gentleman, stabbing and killing him. And this whole case centered around a bunch of shady characters. So here's the story. What happened was that there's a bunch of guys, all of them shadier than the others, having Thanksgiving dinner together. And of course, these guys start getting into fights during the day. They're getting drunk. And there are two people that are particularly antagonizing one another. And one is the defendant and one is this other guy called Crow Hudgings. And there were multiple fights. They are smoking pot all day. And at some point in the day, they decide to get out a gun and start shooting at a log in a fireplace. Now, this was in an apartment in the middle of downtown Denver on Broadway. Well, then they started getting bored and they started shooting outside at the lamp poles and whatnot. So let's just say that the problems during that day escalated, and it ended up with, now here's where the story changes, okay? According to the defendant, they tried to gang up on him. He grabbed a knife and just slashed out to try to protect himself. And the other group of people say no, that he grabbed a knife and killed the person. So what you have here, it's not a whodunit. We know whodunit. But there are some features that suggest it might have been self-defense, and there's some features that suggest that it might be first-degree murder. And I'm not getting into all the details, but there were some reasons why they might think it was first-degree. So what we did was we had people watch this case. So it was a very complex case. Obviously, the prosecution is looking for a first-degree murder verdict. The defense is looking for a self-defense verdict. But the jurors were given first-degree, second-degree, manslaughter, and self-defense as options. So it was a case that required some reasoning. And we asked jurors, after watching the case, to either deliberate and then do the reasoning questionnaire about the case, or do the reasoning before deliberation. So whether or not you reason about the case before or after deliberation, that's what this whole study was about. So let me show you the results of this study. This is the reasoning scores of those who reasoned about the case before, and the other group that reasoned about the case after deliberation. And I just want to say that on this scale here, higher scores indicate higher levels of reasoning. So what you can see here is that the group of people who were asked to reason about the case after deliberation scored much higher than the people who did not deliberate. Okay. So this gave us some indication that deliberation kind of serves as a way of forcing people to think about the case in a much more complicated and complex way. Now, when we went to go publish this study, some of our reviewers raised a really good point. They said, well, you know, the group that did it before deliberation, they didn't have any time to really think about the case. They saw the case and then you ask them all these questions. Maybe it's not deliberation that's helping people. Maybe it's just time that you spend thinking about the case, if there's some time to consolidate the case. So what we did was we went back to the drawing board and we said, okay, let's add another group. And so what we did was we added a group that simply spent time thinking about the case. And this is what we did. In this particular group, they did not deliberate before taking the reasoning test. But what we asked them to do is sit in a quiet room with a tape recorder on and talk to themselves about the case. In other words, we call this group the ruminating group. They just ruminate. So they're not talking to other people, but they're talking to themselves about the case. And we looked at their scores, and look what we found. Basically, rumination, or just thinking about the case or talking out loud about the case, really didn't help your reasoning that much. By the way, the pre and the rumination groups were not significantly different. It's only the group that spent time talking to others that had the higher reasoning scores. So in this particular study, it looks like deliberation is helping jurors. You get more theory evidence coordination after deliberation than you do before, suggesting that deliberation is a good thing. Okay, now let me share with you another study in which we are looking at deliberation. Now, in this particular study, we were looking at jurors' abilities to ignore inadmissible evidence. And by the way, Cami London was also a graduate student of mine. She's now a professor at the University of Toledo. So at the time that Cami was interested in this particular question, there had been lots of studies looking at whether jurors could ignore inadmissible evidence. As you may know, sometimes in a trial, something happens that is pretty damning to the defendant. And so somehow this gets introduced at trial. And the question is, should we stop the trial and start over, mistrial and start over, or do we just give jurors instructions to ignore the inadmissible evidence? Now, as you might guess, it's way too expensive for us to just simply declare mistrials. And so what judges often do will instruct jurors to ignore inadmissible evidence. Well, here's the problem. We had several, I'd say 5 or 6 studies at the time that showed that jurors can't do that. So what you do is you give people instructions to ignore inadmissible evidence, and then you later on look at their verdicts, and they clearly didn't ignore the inadmissible evidence. But the problem with all the studies that we had seen is they were all done at the juror level and not at the jury level. In other words, these were jurors that hadn't deliberated. So what we were going to do is look for jurors before deliberation and jurors after, and see whether they can ignore inadmissible evidence. So let me tell you a little bit about this case. In this particular case, this was a criminal trial for the sexual assault of a child. And by the way, there were 2 different studies that we did, but I'm just going to cover one. Okay. The facts of the case were this: a neighbor of the child was charged with disrobing the child and taking pictures of the child. So the premise was that this child, her friend lived in that house. She went over to visit her friend. Her friend wasn't there, but the child's father talked her into coming into the house and then talked her into taking her clothes off, and he took pictures of her. He also fondled the child, which led to charges of second-degree sexual assault. Okay? Now, in this particular case, what we did was we varied the crucial evidence. And that's the evidence that we are going to either allow or not allow in the case. So apparently we're going to go through this twice. So here's the crucial evidence. In cross-examination, this was the piece of evidence that could be ruled inadmissible. So in some of the groups, the mother says that she became convinced that her daughter was telling the truth when another neighbor told her that the defendant had been charged was sexually abusing another girl 6 years ago. So mom blurts out something in court. And of course, the defense will object. So there are 3 experimental conditions. In the control condition, this crucial evidence wasn't presented. So basically, mom did not testify at all in the control case. In the admissible case, the defense objects. So the mother presents the evidence, the defense objects, and the judge rules the evidence admissible. Okay, overruled. In the inadmissible condition, the evidence was presented, the defense objects, and it was ruled inadmissible. And then the mock jurors were instructed to disregard references to any past record of the defendant. So this now is our inadmissible condition. Don't consider anything with regard to the history of the defendant. So what do you think? Are people able to do this? Well, let's take a look at pre-deliberation. Now, keep in mind that the pre-deliberation verdicts are basically what most other researchers were doing at the time. And here's what we found. You can clearly see, okay, first of all, I just want to point out to you that in the control condition, where you didn't have the mother say anything, you can see that this is a pretty weak case. Only about 28% of, oh, by the way, this is percentage that voted guilty, okay, percentage of the participants who voted guilty. And you'd see that only about 28% voted guilty in the control condition, suggesting this is kind of a weak case, okay? In the admissible condition, where you're allowed to consider this evidence, you can see that fully 95 or 96% of the participants said he was guilty. Okay, they were allowed to use that information. But here's the group that we're really interested in. Were they influenced by the inadmissible testimony? And I think there's a clear and resounding yes. Although not everybody jumped on the inadmissible evidence, you saw that 58% in the inadmissible condition voted the defendant guilty, even though they were not supposed to consider that evidence. Okay, so this is what other people had been finding before. But let's take a look at deliberation. So now we're looking at pre versus post deliberation, and let's take a look at that. So here's our pre-deliberation bars, the ones that you just saw before, okay? And let's go through. Control, what you saw was that it was a fairly weak case before deliberation, and even fewer guilty verdicts after deliberation, which makes sense because once you start talking, people start pointing out that they haven't proved it beyond a reasonable doubt. And in weak cases, you should get a shift towards not guilty, okay? There's a tendency, I mean, the bar is pretty high for a conviction. So in this particular case, they got fewer guilty verdicts. Now let's look at the admissible. You got slightly more guilty verdicts after deliberation than you did before. And this again makes sense. I don't know why this chart goes all the way up to 120, but 98% of the people said that he was guilty in the admissible condition. But let's take a look at this condition because this is the condition that we're most interested in. Remember, we saw that in the inadmissible condition prior to deliberation, people could not disregard the information. But look what happens after deliberation. This group right here was not significantly different from this group. Post-deliberation, you saw a very significant drop in the number of guilty verdicts. In other words, something about the deliberation helped them to follow the judge's instructions and to disregard the evidence. But maybe saying disregard is not really the right answer, because what we did was we analyzed a subset of the deliberation tapes to see whether or not the jurors mentioned this evidence in their discussion. Because remember, the judge says disregard, which means put it out of your mind and don't talk about it. So let's take a look at this group right here and look at whether or not they discussed this evidence during the case. So one of the things we did was we said, how many times was the inadmissible evidence brought up during the deliberations? And what we found was, wow, in the inadmissible condition, it was mentioned even more than it was in the admissible condition. Remember, the admissible group, they're allowed to talk about the testimony freely. In the inadmissible condition, they're told to disregard. It's clear they're not disregarding it. In fact, they are talking about it. Also, we looked at the amount of time they spent discussing the inadmissible evidence, or the evidence about mom, what mom had blurted out. And you can see right here, again, they spend much more time talking about the inadmissible evidence than even the admissible condition, where they're allowed to talk about it freely. So what we found was, what was happening in deliberations was somebody would bring up, well, but what about what the mother said? What about what the mother said? And what you'd see was other jurors policing this, saying, we're not supposed to talk about this. And by the way, I told you that we did 2 studies. In the first study that we did, I mean, it was even more difficult to ignore the inadmissible evidence, because the inadmissible evidence was the fact that they actually found the photographs that he had taken of that young girl, but they were not allowed, they were ruled inadmissible in court, which of course would not really happen that way, but we wanted to test the limits. And what we found was exactly the same pattern, which is that at least initially, people cannot disregard inadmissible evidence. And what we heard sometimes in deliberations was things like somebody would go, but what about this, and they'd mention the inadmissible evidence, and someone would say, we can't consider that. And they'd say, so you're going to let this child molester get free? So there was a lot of anger and tension. But what I guess I'd like to say is, they were able to police each other and do what the judge instructed, although not really, because remember, technically they didn't follow the judge's orders to disregard it, because they regarded it quite a bit. But instead what happened was deliberation, and the policing that happened during deliberation corrected the biases that they had as individuals. So um, I've, I've shared with you 2 studies that we did in our lab. Now I'm going to say conclusions so far, because we still need, there's still a lot that we need to do with regard to deliberations, because some people have found that deliberations can actually lead to a worse product, especially if the group becomes very polarized. You can imagine that could happen. And in other conditions, it might also, the group might not come up with such a great verdict, especially if there's a groupthink going on. But at least from what we have right now, and the work that's coming from my lab, is that individuals alone, just the jurors, may not be moved to think in complex ways before deliberation. They're not being pushed by others, they're not asked to explain their thinking, and they may just assume that everybody's thinking their way. However, deliberation might lead to a superior outcome, because it's during the deliberation that you're asked to defend your thinking, give reasons for your thinking, and also give reasons against others' thinking or support for other people's thinking, and that may lead to more complex reasoning about a case. Okay? So I've given you a little bit of a flavor of what we do when we look at deliberation research, and next time we're going to talk about jury reforms and some other kind of interesting aspects of jurors in our judicial system.